Good morning.
Morning, Josh.
Morning, Your Honor.
Okay, so we are on this morning for a pretrial conference in the CLM trust case versus Brett. Is it Pavel or Pavel? I'm not exactly sure. I do know that Mr. Santos, a default judgment was entered against him and that Commercial Flooring filed bankruptcy and is no longer, to my knowledge, involved in the case in any way. This is also I guess, a sister case to another case. And then just to add more fun to the whole mix, Mr. Carroll, my understanding is that you and your client have reached a crossroads where perhaps the two of you are not interested in going forward in this case together. Is that right, Mr. Carroll?
That's correct, Your Honor.
My only concern is the extent to which, if you have an understanding and can share it with me, Mr. Carroll, that Mr. Pavel intends to participate in the case either on his own or with the assistance of another attorney, if and when the case goes to trial.
My understanding is he does not plan to participate. What he's told me is that he doesn't want me to do anything further. He's going to file a Chapter 7 bankruptcy, and he himself is not going to do anything further.
Okay. And I know that had been the announcement previously that that was his intention. But as Mr. Fallon correctly pointed out to us recently when we were wondering what to do with the case, was that no Chapter 7 has yet been filed. And so obviously when it is, if it is, we will take action in that way. Mr. Fallon, what would you have the court do relative to this case and Mr. Pavel and of course the other case?
Um, well, it's just a simple promissory note case. I guess we wanted to get our judgment as expeditiously as we could, and if it turns out to be worthless, then that's what it is. I don't think it will do well in the Chapter 7, but since he hasn't filed one, I feel obligated to see if I can get a judgment on the note.
Okay. My inclination, Mr. Carroll, to the extent that you are able to communicate to your client or that he's, willing to listen, typically what would happen is I would grant your motion to withdraw. But likely, I believe I have actually seen your motion to withdraw, or the proposed order that was submitted. And the main issue that I would have is my inclination would be to set the case for a date certain, and make sure that that's included in the order allowing Mr. Is it Pavel?
I think it's Pavel, Your Honor, yes.
Pavel, allowing Mr. Pavel to withdraw or allowing you to withdraw from representing Mr. Pavel so that the order allowing that withdrawal is clear to Mr. Pavel what the next thing is. And then if he doesn't show up for whatever that next thing is, then I will take whatever action Mr. Fallon suggests to me that I should take. Unless, of course, in the interim, he files a Chapter 7 and notifies the court that he's done so.
I am fine with that, Your Honor. If you want to give me a date to put in the proposed order, I can.
Well, I'm happy to put it in the proposed order. What I would like for you to do is just send me over your proposed order in Word format if you didn't already, so that I can edit it. Because I believe, looking at the file, my prior observation of it is that you had, I think today or tomorrow at the latest was the 10th day of notice, even though your client was saying, I don't want him. That 10th day of notice per the rule would have either been today or tomorrow. So the order is now right for me to enter. And so if you've already sent it to me in Word, I will adjust it accordingly. If you have not sent it to me in Word and you could, that would be helpful.
Yeah, I've sent it to Mr. Freehoff in Word.
Excellent.
I can confirm that.
Thank you. So what we will do then is probably, Mr. Fallon, I'm going to get with Mr. Freehoff and figure out when the other one, where it is procedurally, when it is, and try to run them together on some day, perhaps 20-ish days from now. So that way there's some reasonable time for him to take a Chapter 7 step or to try and find an attorney or something. And then if he does not appear, then you can ask the court for whatever relief you believe you're entitled to have.
So we're off for tomorrow, for sure.
Yes.
And you'll send a date in an order for a future date, and we'll see what happens.
Right.
But
And
we'll
it
set
will be relatively soon. I mean, looking at my calendar, I can tell you that it would most likely be perhaps in mid to late May. So I'm like I said, I'm going to target about 20 days. The most would be a full 30 days to the first week of, or excuse me, to the last week of May. which would be almost a full 30 days, but that would be what we would do next.
But we'll
Okay?
have them together then, and so they'll just be.
Yes, and we would consolidate them at that point. Yes, Mr. Freya.
Hi, Judge. I just wanted to ask, Mr. Fallon, Mr. Kelly, I assume that you're not relevant to this question, but Mr. Fallon, are you okay with the bench trials being by Zoom?
Yes, of course. Whatever is
Okay.
easier for the court.
Okay, and then I just wanted to mention that the trial date won't only be in Mr. Carroll's withdrawal order. There will also be a separate notice issued with the Zoom invite and everything. So you'll have very clear understanding of when the reset is.
And just be clear, my client was the one witness on the note, but also had another witness in case it got more complicated. But so there might be two witnesses if that matters to the court.
Yeah. And that sounds similar to what your time announcement was. I think it was like 30 plus minutes, which is fine. Mr. Carroll, I do have one last question for you. In the order, typically it will say that, you know, that they've been reminded that they're obligated to respond and that they still have to undertake whatever steps. One question I have for you is, have you provided us with a physical address only, or do we have, and are you able to provide us with an email address that's good for Mr. Pavel? Because it makes it, as you might imagine, way easier to make sure that we sent notices to people if we have a functional email address.
I do have a functional email address that I can provide to the court.
That would be very helpful. Can you tell us what that is, Mr. Carroll?
Yeah, give me just a second.
Sure.
Oh. So I've been able to communicate with him at brett.pavel@cfs-atlanta.com, and I can email that to Mr. Freehoff as well.
Thank you.
Okay. Thank you very much, Mr. Carroll. I'm sorry that it didn't work out in terms of your representation with your client, but I appreciate your efforts up to now. And Mr. Fallon, thank you. And like I said, we will reset all of them to a date jointly. And then we will, like I said, that will be between 20 and 30 days from now. Okay.
Thank you so much, Your Honor.
Thank you all. Have a good day.